Hi, my name is Haley McConnell, and today I will be introducing to you police discretion. So, police discretion is a very broad topic, and it truly permeates the daily work of police officers. Police officers have a wide range of options available to them given the diverse circumstances they may encounter, so I will focus mainly just on the key aspects of discretion. In my presentation, I will explore the factors, limitations, and risks associated to police discretion, and then I will highlight on its application in the Yukon, and then touch on future opportunities on how to make it more effective. To support my research, I interviewed John Phelps, the Deputy Minister of Justice, Callista McLeod, a community conference coordinator with the Yukon government, and Candace McKeechan, an RCMP officer here at the Whitehorse Detachment. Their feedback is reflected throughout this entire presentation, but especially as it relates to the Yukon context. So, what is discretion? So, according to Griffiths, discretion is the power or right to decide or act according to one's own judgment. However, more specifically, according to the website Policing and Society, police discretion is the freedom of judgment and choices given to officers in specified circumstances in accordance with their governing policies. And authority to use discretion is established in statute and throughout common law. So, as I mentioned before, discretion is complex and wide-reaching. It can range from not charging a minor consuming alcohol to situations requiring force, all the way to criminal offenses and whether or not to arrest. Before I begin, it is important to note that there are environmental, situational, and organizational factors that all have an influence on the decision-making of the officers. No officer is the same, and therefore there's no absolute right choice. Secondly, as the seriousness of the incident increases, the discretion used decreases. So it's not as likely an officer can or will use discretion as an offense becomes more serious. This is when they are more inclined to make an arrest or go through the formal justice system. And lastly, discretion is not absolute and it must be exercised honestly and transparently. So discretion must be justified and police officers must be accountable for their decisions. So I will begin with some background. So discretion has been recognized as an important part of policing throughout its evolution. So policing originated in England in the early 1800s, and it was questioned if creating a police force was the right decision, and if created, how to keep the force accountable. This has been debated for more than a century between political, social, and philosophical bodies. Then there was the American Bar Foundation research conducted by Frank Remington in the 1950s that showed that police work is complex, uses enormous discretion, and that discretion is at the core of police functioning. This research also suggested that the control mechanisms that pervaded police organizations were incompatible with the problems they are confronted with daily and how their services are delivered. And then further research conducted by the American Bar Foundation confirmed that police work is complicated, and while they use discretion throughout their work, only a small portion of police time actually focuses on criminal matters. So, why is discretion important? It is really important because there are no written rules for what an officer must do in every situation. It is possible to come across situations that have never occurred before, and therefore the only way officers know how to assess it is with the knowledge and training they possess. It is also impossible to enforce all laws at all time, so officers must practice selective or situational enforcement, which is the power to choose whether or how to sanction a person who has violated the law. Even if they tried to fully pursue all crimes at all time, there wouldn't be sufficient resources to investigate each and every one and make arrests. So discretion is actually needed to filter offenses so only that the most important ones are investigated. Police services lack resources to enforce each law, so they must have flexibility for the officers to choose and decide which laws should be enforced. It is also important to recognize how police work is conducted. So first, an officer enters a situation that is fluid and often must make quick decisions. Second, the officer makes these decisions based off their knowledge, experience, and training. And while all officers do have a supervisor, most of police work is conducted either alone or with a partner, and generally supervision of their work occurs after the fact. So now I'm going to tell you guys about the 3 key factors that appear to form the decision-making basis for the exercise of police discretion. So that would be environmental, organizational, and situational. So for environmental, it is nature of the community and external resources available. organization is specialized units. So, for example, domestic violence unit, youth or school liaison officer, as well as department training and department policies. And situational is such as circumstances of the offense. So, if there were weapons or violence, etc. If there was injuries or property damage, if there was substance use involved, and the demeanor or previous record of the offender, or say if the offender had been previously referred to an alternative measures program, as well as wishes of the victim, employment, and in cases of youth, parental support or stability of home, and lastly, where it relates to use of force, so the officer's perception of risk to the public or to themselves. So now I'm going to kindly ask you guys to please refer to page 4 of my outline. So this image is a visual representation of a concentric layered wheel that represents the rapidly evolving and dynamic nature of police work. So the center of the wheel is the actual situation with the officer using CAPRA. So that stands for Clients, Acquire, and Analyze, Partners, Response, and Assessment. And it is a problem-solving model. And then the circle actually builds outwards, and that helps the officer form a proper risk assessment, which includes situational factors, officer's perceptions, tactical considerations, and the subject's behavior. And then finally, the outer layers represent the police interventions and the responding the officer may select. And now I'm going to explain a bit of background on use of force. So the philosophy of use of force on citizens by police is that the force should only be used when absolutely necessary. Policing in this manner will help the officers to respect the constitutional guarantee of all Canadians to life, liberty, and security as provided under Section 7 of the Charter of Rights and Freedoms. When force is used excessively or unnecessarily, the relationship of trust between the public and the police can be at jeopardy. Therefore, it is crucial that officers work in ways to minimize the necessity to use force whenever possible. Now, I'm going to talk to you guys about how discretion is not unfettered and it has its limitations. So, the decisions the police make are ultimately scrutinized by the public, courts, or other review bodies. So, police have discretion to arrest and lay charge, but after that, the Crown then takes over and makes a decision whether to proceed with the prosecution, stay the matter, or refer the offender to a restorative justice program. So oversight occurs in courts, and police conduct is reviewed by a judge. So if it's believed an officer has abused their discretionary powers or has violated a person's legal rights, the judge can dismiss evidence or even the case entirely. Furthermore, police are subject to the criminal code as demonstrated in the R.V. Beaudry case. So, Beaudry was convicted of obstruction of justice for having failed to gather evidence in an incident involving another police officer who was suspected of impaired driving. He was convicted of obstruction of justice because he failed to take a breath sample. This case is important because it confirmed that police discretion is not absolute, it has its limits, and that police must be accountable. There are a number of police oversight boards and commissions here in the Yukon, such as the RCMP have to comply with the RCMP Act and are subject to review from public complaints and commissions, and depending on the nature of the allegation, are subject to review by another police force. It is also so important for discretion to have its limits because unlimited discretion can lead to corruption, biased policing, poor quality police investigators, or police responses that put the public at risk. So now I'm going to talk about, or a little bit about, application of discretion in the Yukon. So some examples of how it's applied here in the Yukon are such as the following. So you could have traffic offenses such as speeding, and in certain cases an officer will simply let the offender go with a written or verbal warning. And then with situations such as underage drinking, at times the officer will simply have the offender pour out their liquor, and depending on the level of intoxication of the minor, will take them home to their parents rather than giving them a ticket or issuing an arrest. And then you can have situations such as minor property damage, and the officer can look at alternatives for the offender to repair harm to the community rather than laying a charge. In this case, they have to talk to the victim about how they would feel and how they want the situation handled. So, for example, if somebody threw a rock through someone else's window and it broke, the police would first go to the person whose house it is, so the victim, and see how they want the situation handled, like what they would like done about it. If the victim says all they want is for the window to be repaired and not to lay a charge, and the offender agrees to the repair, then that could be the end of the formal case. But with a more serious offense like assault, police have used restorative justice alternatives to help the victim and offender repair their broken relationship. So repairs like these are not likely to occur in court settings. They usually only occur using restorative justice or community conferences, which are practices involving the victim, offender, and support people. And they aren't about punishments like the courts are. They're about restoring relationships and working together to move forward. Also, in 2016, an MOU between the RCMP, the PPSC, and Corrections established a pre-charge diversion program for the territory. So far, Dawson City, Watson Lake, Old Crow, and Teslin have a letter of agreement with community justice workers to manage this program. If police refer matters to them, they take it, they assess it, and they maybe have a restorative justice conference, which is to figure out what is the best way to repair the issue. So that could be such as restitution or counseling if it's for something like addiction. And if the agreement is completed within 4 months, then the RCMP are notified and they close their file on the matter. But if this agreement is not completed within that time frame, then the RCMP may proceed with a criminal charge. And then with a serious offense such as impaired driving, at times the police have opted to issue 24-hour suspensions and drive the offender home. But in these scenarios, police need to weigh the seriousness of the offense, the community expectations, such as programs like MAD, the current justice system constraints, and the impact their actions may have on preventing repetition of this offense. But in places such as BC, there has been a move away from criminal charges and an increased utilization of administrative measures. So that would be such as roadside suspensions and fines. All right. And even after the decision to arrest is made, police have discretion on how and if to release someone. While authorities for arrest and release are in the criminal code, many of the officers utilize the word may rather than shall. So again, this provides police with flexibility. So for example, once they arrest the offender, they can simply let them go, or they can let them go with just a court date, or they can let them go with a court date and a document of conditions they must uphold until modified by the court. So these conditions can consist of things such as reporting to a bail supervisor, not drinking alcohol, not coming in contact with the victim, and not attending specific locations, etc. And lastly, they can detain the offender and make them see a judge within 24 hours. So in the Yukon, when dealing with minors, police are inclined to utilize discretion more often than not based on principles of the Youth Criminal Justice Act. So here, like in these scenarios, police have to consider if they can make a referral to a community agency to help the offender take accountability, provide a written or verbal warning, or take no further action at all. And now I'm going to elaborate a bit on future opportunities for the Yukon and discretion. So there are opportunities for discretion to be utilized more effectively in the Yukon. So more structure could be put around pre-charge diversion for both youth and adults. So right now there is a very structured system of post-charge diversion for youth, but if more supports were put into pre-charge opportunities for resolving issues to the benefit of the victim and the offender, it could allow for repair to occur earlier and would eliminate need for a formal court appearance. This would also better support the formal justice system by freeing up resources for more serious matters. In addition to more structured programming, better education and training would also promote opportunities for diversion to occur. So if the officers understand the population they are dealing with, such as some of the vulnerable population of Whitehorse, they could better understand how these people's lives came to how they are, and then could exercise their discretion more effectively. So strong internal processes would empower officers to utilize these resources. And at the moment, every community has an Indigenous court worker willing to work on diversion, but with more structure, education, and training, there could be many more opportunities for successful diversions. The criminal justice system would be very supportive of the RCMP exercising more discretion, because then it would place a lot less reliance on the jails. But the overall key to improving these diversion efforts is community involvement. So, all in all, the criminal justice system could not function without police exercising discretion. They would have way too many cases and not enough resources to handle these cases. If police were ordered to make an arrest for every crime, no matter how small, the system would become overwhelmed, and that is why discretion is so crucial. But, however, this broad power needs to be balanced with accountability. There needs to be oversight both through internal supervision, policies, and practices, as well as external reviews of actions, inactions, and conduct. But that is all I have for today, and I thank you very much for listening to my presentation.